Hi everybody, today I'm going to tell you about the very popular criminal law case called The Crown and Dudley and Stephens. This case involved four sailors on an ocean-going freighter who were cast adrift in a life raft after their ship sank in the middle of the Atlantic Ocean. The sailors had no food or water and they had no equipment to source food from either. After recovering from the shock of the shipwreck, the sailors began discussing their various options. Dudley, who was the ship's navigator, estimated that they were roughly 1,000 miles away from land, and the storm had blown them way off course in the hope of any ships passing by may see them and rescue them. Stephens was the ship's doctor. He estimated that the crew could live for at most 30 days without food. He did, however, mention that if one of the crewmates died within this 30 days, then the others could live that bit longer if they fed on the body. Parker was a young cabin boy on the ship and was very malnourished at this time. On the 18th day, Dudley decided that they all draw lots and that the loser be killed and eaten by the other crewmates. Stephens accepted this proposal. However, Brooks rejected it and Parker was not consulted. Dudley and Stephens decided that Parker was going to die soon anyway, so Dudley decided to kill him. For the next 4 days, all of the sailors, including Brooks, fed on Parker's body and drank his blood. 5 days after the killing, a passing ship spotted the crewmates and saved them. They were in turn brought to the port. They then explained what happened to Parker to the authorities, and after recovering from this ordeal, Dudley and Stephens were placed on trial for murder. The trial opened in Exeter on the 3rd of November in 1884 under Justice Baron Huddleston. Justice Huddleston returned a special verdict whereby, on the findings of the jury, the case was to be heard by a panel of 5 judges. This panel was led by Chief Justice Lord Coleridge, and it was for them to decide whether on the case facts this was a murder or not. The issue was whether there was any justification in killing Parker in order for the defendants to survive. It was to be discovered whether the defendants could plead that the killing was necessary, which would therefore give rise to a defence to murder. Necessity is a defence that permits a person to act in a criminal manner when an emergency situation, not of the person's own creation, compels the person to act in a criminal manner to avoid greater harm from occurring. Queen's Counsel Arthur Charles led for the prosecution. He outlined his legal arguments and suggested that murder had been committed. He rejected the necessity defence and he also rejected the insanity defence. He submitted that based on the depositions the sailors had made, that they were aware of the quality of their actions and knew what they were deciding at the time of Parker's death. Queen's Counsel Arthur Collins led for the defence, and he addressed the issue of necessity in this case. He stated that the sailors' deaths were inevitable without the use of Parker's body, and that Parker was going to die soon anyway. He also reinforced that there was no prospect of survival for these sailors, and therefore the defence of necessity could be justified in this case. The judges, however, found that there was no defence of necessity to a charge of murder on the basis of legal precedent and on the basis of ethics and morality. Lord Justice Coleridge further found that the defence of necessity could not be applied to a charge of murder based on the case facts. He also held that it is not possible to justify the killing of one individual in order to save the life of another on the basis that the killing is necessary to do so. In response to the defendant's argument of self-defence, the courts noted that in order for self-defence to be justified, that a real and present physical threat must have existed, and that Parker, the young cabin boy, presented no such threat. On commenting on the dangers that applying necessity as a defence to murder could have in future cases, Lord Justice Coleridge commented that, though law and morality are not the same, and many things may be immoral which are not necessarily illegal, yet the absolute divorce of law from morality would be of fatal consequence, and such divorce would follow if the temptation to murder in this case were held by law in absolute defence of it. So this quote basically highlights that the judge really did take morality into account in coming to his decision. The court did, however, recognise the exceptional circumstances of this case and went as far as stating that anybody could have done the same had they been in the position. However, the court once again reiterated that because Parker was the weakest, this did not make his life any less worthy than the other sailors. It was stated that we are often compelled to set up standards we cannot reach ourselves, and to lay down rules which we could not ourselves satisfy, but a man has no right to declare temptation to be an excuse, though he might himself have yielded to it. Dudley and Stephens were ultimately sentenced to the statutory death penalty, although interestingly enough this was reduced to 6 months imprisonment based on the advice of the Home Secretary at the time, William Harcourt. It is also quite interesting to note that this case in fact gained a lot of public sympathy whilst the trial was ongoing and after the trial. It divided public opinion into one side believing that the sailors should have been charged with murder and the other side believing that the sailors shouldn't have been charged with murder. It's a really good example of showing you how the law is not always black and white and can often be quite blurred. Whilst this case is almost 140 years old, it has been relied upon. However, it is also important to note that the law has changed since Dudley and Stephens in some areas, such as new defences being brought in. Counsel today could in fact argue the defence of diminished responsibility, which didn't exist back in the time of Dudley and Stephens. This once again shows you that it's really important to stay on top of your case law, especially when presenting a case. Overall, it seems that the defence of necessity can only be used in extreme cases. However, the case of the Crown and Dudley and Stephens remains an engrossing discussion in criminal law. It also sparks great debate and interest to this day. Thank you for watching.